Welcome to Crash Course Injury Law with Joe Ghabour.
Welcome back to Crash Course Injury Law with Joe Ghabour, founder of Ghabour Law. Joseph is a personal injury attorney licensed in New Jersey, New York, and Florida who helps injured people understand how liability works in everyday situations, from grocery stores to sidewalks and apartment buildings. I'm Lisa Mosby, your host, and today we're talking about slip and fall accidents in New Jersey and what really determines whether a property owner is responsible. Joe, thanks for being with me today.
Thank you for having me, Lisa.
Could you start by explaining what premises liability means in the context of a slip and fall case?
Sure. So, premise liability basically is based upon the fact that every person that owns a property has a responsibility to make sure that his or her property is kept in a reasonably safe fashion. If someone gets hurt on someone's property as a result of a dangerous condition that wasn't taken care of, the owner of the property, such as a landlord, such as a store manager or store owner, such as a business, they may be responsible for the injury that the person sustains.
And then what conditions need to exist for a property owner, store, or landlord to be responsible for someone's injury?
Well, there are a few key things. So the first thing is there has to be a dangerous condition, such as a spill, a broken step, something that is, dangerous. The second thing, which is very important, is that the owner or the person responsible had to have known about it or should have known about it. The third thing is they didn't fix it. They failed to warn the people of it in time. And if all of those things line up, then you have a decent premise liability case against the defendant.
And many people assume that a fall automatically means they have a case. What are some situations where the property owner is not legally at fault?
So the first thing we have to show, obviously, is that there was a dangerous condition. That's usually easy enough to determine because the person was injured. The plaintiff in this case was injured. The big issue really is showing that the business owner or the landlord had notice of the condition and failed to do anything about it. And that's really where the fight usually comes in. A lot of times the business owner will say, I had no idea that there was water in the aisle. Of course, our response is, well, you should have known if you were doing inspections, but sometimes the fall will have happened right after someone spilled some water on the floor, and there wasn't enough time for the business owner, for example, to clean it up. So that's really the big thing. In New Jersey, actually, there's, like, people fall on snow and ice. If you have a single family home or a two family home where the owner of the property lives on it, and that person doesn't shovel the snow or doesn't salt the walkways, doesn't do anything at all after a snowstorm, and someone falls, believe it or not, there's case law in New Jersey that says the landlord of the property is not liable because he did not undertake to remove the snow. Once you do undertake to remove the snow and you don't do a good job of it, then you become liable. So there's a lot of nuances to the law, and you really need to consult with an attorney who's experienced in personal injury to make sure that you have a viable case. And if you do have a viable case, how you're going to go about proving it.
I have to go in a different direction here for a second. If we have so many people that work from home, small business owners, if something happens when someone's coming to see them while they're working, drop off papers or documents, and they hurt themselves on their property, are they also liable, or would their company be liable? How does that play into this law?
Well, if you are working from home, obviously working for a company from home, and someone falls on your property as they're dropping off documents or what have you, you as the owner of the property is going to be liable. Technically, the employer could be liable as well because you were, acting at the behest of the employer. But that's going to be a much more difficult fight to prove that the dangerous condition resulted from the actual employer and not from the homeowner or the property owner where the person fell.
So we covered companies when you're working for a company, but what about those folks who are self-employed and work from home? If they have clients seeing them or somebody slips and falls on their property, what is their liability?
It's the same exact thing. If there is a dangerous condition that that self-employed individual working from home knew or should have known about it and did nothing to remediate it, then that person is going to become liable. So if, and in this day and age, a lot of people work from home still. So if you're working from home and it snowed and you have to shovel the snow and put some salt down and you don't do a good job and somebody falls on black ice, you're going to be liable. If you're working, if you have your own home, your homeowner's insurance is going to have to, pick up the tab on that one. But again, we're going to run into a situation where you're going to have to explain to your homeowner's insurance that your residential property is being used for business purposes, and you're going to run into all sorts of issues. Again, insurance companies will use any excuse to not pay. So expect a fight if you're working from home and somebody gets injured coming to the house to give you things related to the job that you're performing. So be prepared for that.
Or have business insurance for your business? Would that be an option for somebody?
Absolutely. If you have business insurance because you are, self-employed and you want to make sure that you have coverage for, liability number one, in case your equipment gets stolen or what have you, that's definitely good. And it's very inexpensive to have business liability insurance, especially if you're a solo individual or if you have a very small company working out of, your house, which happens a lot more often than people think.
It really does in this day and age. What kinds of evidence make these cases stronger, especially early on when someone is still dealing with the injury?
Well, of course, the best evidence is, either a video recording of the accident or a firsthand witness, someone who actually saw the accident happen. So when we get retained after an accident, and this is why it's very important to call a personal injury attorney right away, we send out what's called a preservation letter to the business. If, let's say, for example, you fell in a grocery store or in a location where there are cameras, we send out a preservation letter, which basically puts the owner of that property on notice that we represent the person who was injured and we are asking them to keep the video recording for a specific period of time until the case is resolved. So we'll tell them to keep the video for the period of 12 hours before the accident and 12 hours after the accident, until the matter resolves. Now, if they don't do that, they get the letter, and of course, it's sent out via certified mail, return receipt, so that we can verify they received it. But let's assume they get the letter and they don't do that. If the matter goes to trial, we can actually get what's called a instruction from the judge telling the jury that these people were notified to keep the video and they failed to do so. So if you want to consider that that video, had it been provided, would have been adverse to the defendant's position, you can do so. It's definitely not an instruction anybody, any defendant wants to have given against them in court. So more often than not, they will preserve the video. And that's why it's very, very important that you consult with an attorney, because videos get deleted. Nobody's got indefinite DVRs on these camera systems. So after 24 hours, after 48 hours, after 30 days, after 60 days, it varies obviously from company to company, but that video is going to get overridden and it's going to be, new things are going to get recorded. So you have to send out that letter as soon as practicable after the accident. And if it falls within the time frame where they still have the video, they have an obligation to preserve it.
And you had mentioned that insurance companies, they want to pay out the least amount possible, of course. When insurance companies evaluate slip and fall cases, what factors tend to matter most determining whether they'll negotiate or just flat out deny the claim?
Well, the first thing is whether or not a dangerous condition existed. Was there a hazard or not? The second thing is whether the person they represent, the owner of the property or the business, had notice. Whether that person had notice of the condition or should have had notice of the condition. Again, If they had no notice, and if the dangerous condition just occurred, then they're not legally liable. So the insurance company is going to send out a letter saying, we've evaluated the matter. We don't think our client is liable. We're not paying anything. And that's, usually what the insurance company will do. Now, if there is a dangerous condition, if there is sufficient evidence to show that there is notice, for example, they have a video recording of the accident itself, and they see that, there was water on the floor for the past 30 minutes, and employees were walking down the aisle and didn't do anything about it, then they have notice. So that becomes more of a situation where the insurance company is likely to make an offer to settle the matter. May not be the best offer, but at least there'll be an offer on the table.
So let's give some specific guidance here. If the injury happens inside a business, how does the claim process typically start, and what should someone expect from that first stage?
Well, if the accident takes place in a business, the first thing you should do, obviously, is, if you're able to. I mean, if you are seriously injured, then you're not gonna be able to do what I'm telling you right now. But if you're okay and you can get up, go to the manager, file a report. An incident report should be filed by you with the business itself, with the business owner, with the manager, so that you can document the fact that this happened. Obviously, if you're seriously injured, someone's going to call 911 and they're going to get you an ambulance. But if you're able to make an incident report with the business owner, do so. That's the first thing that happens. After that, obviously, get medical treatment. If you're injured, you will need treatment just to make sure you're okay, number one. And number two, to document the treatment that you underwent.
And then for someone who's unsure whether unsafe conditions caused their fall, what steps should they take right away to protect their rights to move forward and get help or medical attention?
If you are uncertain whether or not you may have a case against the business owner or the landlord, the first thing you really should do after you get your initial medical treatment is to consult with a personal injury attorney. Costs you nothing to speak with a personal injury attorney for the first time. At least you'll have an idea as to what your situation is. You'll be able to explain to the attorney how you fell, what caused you to fall, and the attorney will be able to give you guidance as to whether or not a case may exist. And of course, after that, the attorney will be able to guide you throughout the course of the litigation itself, should the matter require litigation. Again, if you don't know, ask someone who does this for a living day in and day out. The attorney will be able to provide you with good advice in terms of what you need to prove and what the situation that you are in will entail going forward.
And Joe, do you have any final thoughts for folks? Because this is really complicated and there's a lot of intricacies to it. Do you have final thoughts to share with anybody who might be in this situation right now as to things that they should be looking for or where they should take action?
Well, if you're injured in a business or on somebody's property, keep an eye out for any cameras that may be in the area. See if there are any witnesses that may have seen the accident happen. Make sure you take photos if you're able to, or have someone take photos of the location where you were injured. Even if you've been in that area several times before, that day you may not have seen a hazard that was there before. So make sure that you're able to document all of this and speak with an attorney. You got nothing to lose and everything to gain by asking for advice from a personal injury attorney.
Thank you so much for today, Joe. This was great information.
Thank you, Lisa.
That's it for today's episode of Crash Course Injury Law with Joe Ghabour. To learn more about slip and fall claims, property owner responsibilities, and your rights after an accident, visit GhabourLaw.com. You'll find clear, practical resources to help you understand your next steps. Thanks for listening, and don't forget to like, leave a review, and subscribe to the show. We'll see you next week.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.